my name is Karen Brody and I'm the head of the money team at Dean's Court Chambers. This talk is about how the courts approach cases where the parties entered into agreements limiting the claims of one party in the event of divorce. When you have a case where there's such an agreement, look first at whether or not the agreement might be a magnetic factor. In rare cases, it will be clear that the P&A is going to be decisive, so it will be given full weight and not departed from, as in the case of Crossley and Crossley in 2008. There, two wealthy individuals agreed before they married that neither would make any claims in the event of the divorce, and each would keep what they came into the marriage with. The marriage only lasted a year. Mrs. Crossley applied for financial orders, and Mr. Crossley applied for her to show cause why the P&A should not rule the outcome. At first instance, it seemed to be so straightforward that the case was listed for a day, and both parties were ordered to file Form E without exhibits. The wife appealed. The Court of Appeal held that the procedure adopted below had been correct. Although the existence of a P&A does not have the effect of ousting the court's obligation to apply the Section 25 factors, in this exceptional case where there was a strong possibility that the wife would receive no award, the P&A was a factor of magnetic importance, so the burden was on the wife to show why it should not be followed. The wife then withdrew her application. In the more usual scenario, where you have a case where there's a P&A, but there could be reasons why it should not rule the outcome, the leading case is Radmacher and Granatino, heard in 2010 by the Supreme Court. The court set out the principles which should be applied. In essence, first, was the agreement entered into voluntarily, i.e. was there pressure placed on one party to agree? The fact that your fiancé won't marry you unless you enter a P&A will not be sufficient. See the case of KA and MA. But if a party can establish that he or she was bullied so that their free will was overborne, it cannot be said that the agreement was entered into voluntarily. Second, if it was entered into voluntarily, did the party have a full appreciation of its implications? If the answer to both of these questions is yes, then the court should give effect to it, unless, in the circumstances prevailing, it would not be fair to hold the party to it. Let's consider what full appreciation of its implications means. In Kremen and Agrest in 2012 in the High Court, a case concerning a post-nuptial agreement, the court found that the husband had not only pressured the wife to enter into the agreement, but was guilty of material non-disclosure, and the wife had not had legal advice. How can you fully appreciate the implications of a P&A without legal advice? Mr. Justice Mostyn said it would only be an unusual case where it can be said that absent legal advice and full disclosure, a party can be taken to have freely entered into a marital agreement with full appreciation of its implications. In other words, the Radmacher test was applied. So in that case, the agreement was vitiated, which means that the court will give it no weight at all and will deal with the application as if there had been no P&A. Look for misrepresentation or fraud as well, because these factors will point to the party not having fully appreciated its implications. Most of the case law concerns valid P&As, i.e. the party did have legal advice, wasn't bullied, and open, honest disclosure had been made, i.e. it was voluntarily entered into with a full appreciation of its implications. When we have a client who has entered into a P&A in these circumstances, in almost every case, he or she will have been told by a lawyer very clearly not to enter into it. They then go on to sign it despite our advice. When the parties then divorce, our task will first be to look at the Radmacher test, but if we consider it's likely to be upheld as valid, the next question is it unfair? What does unfair mean? The court will look at the Section 25 factors and the principles of need, compensation and sharing. But the fact that there is a valid P&A can alter what is perceived as fair. It will depress the level at which needs are met. So if the P&A provided for, say, £300,000, which the court decides would not cover reasonable housing needs, and but for the P&A, the person who signed the document would have received, say, £500,000 to meet housing needs, the court will adjust the sum in the P&A and award more, but only enough to meet a fairly basic housing need. In other words, not the £500,000. In the case of KA and MA, the court said, A fair outcome in the assessment of both housing and income needs in this case must reflect the fact that this wife agreed to restrict the ambits of her financial claims should the marriage end in divorce. Another example of the court's approach to the issue of need is found in Luckwell and Limata, which was heard in 2014 in the High Court. Here the wife's family was very wealthy and there was a prenup followed by 2 supplemental agreements during the marriage when the wife's parents wanted to give her large sums of money. The husband was to receive nothing in the event of divorce. The agreements were all held to be valid, i.e. they passed the Radmacher test, so the court had to decide whether they were unfair and so concentrated predominantly on the husband's needs. Now, needs are an elastic concept. Do we interpret them generously or conservatively? The parties had children. The court was concerned that they would have markedly different homes and standards of living with each parent, which was not in the children's interests. The court ordered that the wife should provide a home for the husband and a lump sum for furniture and for a car. The house would be sold when the youngest child was 22. 55% of its sale proceeds would go to the husband so that he could buy a property for himself. Obviously, had there been no valid agreements, the husband would have been awarded far more. So is the assessment based purely on need? The most recent authority is the case of Brack and Brack, in which Lady Justice King emphasised that the court remains under an obligation to take into account all the factors found in Section 25 and should not focus on need alone. I hope you found this summary useful. Goodbye. Thank you for listening.